Good morning, everybody. How we doing this morning? Minute here, we'll get started. So, I been putting out some shorts, some smaller videos, whatnot. I meant to sit down and do it live yesterday, but I was busy with things more important, people more important. So I want to get on here this morning, and I want to talk about probable cause a little bit, and presumption of innocence, and how I would present this as a defense attorney, and how defense attorneys present probable cause and presumption of innocence to the jury or to a judge, and what they mean, and how I see the case in Delphi right now and what the problems are, because they're starting to be major problems for everybody involved. So, what's probable cause? Probable cause is enough evidence to charge a person with a crime, or for a police officer to search a person's property. It's enough evidence for a grand jury to indict a person. It's enough evidence to bring a person to trial. It's not enough evidence to convict a person, though. It's only enough evidence to bring that person before a judge or jury, okay? So Nick McClelland better have a case against his person. What is the problem with him not releasing the probable cause? Because you have a presumption of innocence. Everybody is presumed innocent until proven guilty, right? What is a presumption of innocence, and how would one define that? I like to explain the presumption of innocence, explaining this is not a situation where you're being asked to decide who told a better story. I don't want to put you between the prosecutor and myself and ask you to choose whose side's better. By default, your job is to give a verdict of not guilty to my client. The only way you can give a verdict of guilty and leave my client's side is if the prosecutor presents enough evidence that there's reasonable interpretation of the facts that my client is guilty, and there is no doubt in your mind that my client is guilty. So let me use the Pink Floyd explanation that we used in the law school. Okay, so the Pink Floyd theory, or Pink Floyd comparison, is that the criminal justice system has led my client down a long road. This is me explaining, if you were a jury or something listening. I'm going to explain probable cause, presumption of innocence in the Pink Floyd theory. So if I'm sitting here explaining to a jury, I would explain how the criminal justice system has led my client down a long road. He's now arrived here in front of you, where a brick wall stands between my client and prison. The brick wall is reasonable doubt. Unless the government, Nick McClelland, knocks down every brick in that wall, even if one brick still stands, my client goes home, okay? No bricks can stand. No pieces of brick. Because any type of brick or piece of brick would be a little doubt in your mind that, well, maybe, and if you have any doubt, well, maybe, you cannot convict my client, okay? My client goes home. So I would say, now that you have heard over the last few days, and then I would present exculpatory evidence of my defense, and 3 witnesses testify that my client was nowhere near the scene of the crime that day, okay? There are 3 giant bricks right there that you must now remove. So let me go a little further and say that Richard has an alibi. Okay? We don't know. We haven't heard enough. Say Richard has an alibi. So my client What Richard has an alibi for eternity. That would be another brick in the wall, regardless if it's his wife or coworker. That has again, because I could go back to the the state could bring up the 3 witnesses that saw Bridge Guy and say, "Did you see Richard Allen that day? Is this the man?" They could say, "Yeah, it looks like him." But if I bring up somebody that also witnessed seeing Richard on the 13th between this time and this time, I'm now planting a seed of reasonable doubt in your head that I not. If I can give you a credible witness. So you see how it conflicts itself. That's why a state likes to have enough propulpatory evidence of their own that they're confident in a conviction regardless of what I pull out of my hat. Witnesses, alibis, this, that, or the other thing. Richard was at work. Richard didn't murder the girls. Richard isn't the sole actor, and more arrests may be made. There's 3 more bricks in the wall. See where I'm going with this? So if Nick McClelland in the state were confident that they arrested the correct man for this murder, put out the probable cause affidavit. That would co-sign your actions. They're not co-signing their actions with any legatory forms. Give us papers. Give us a good reason for your actions, McClelland, which would be a probable cause affidavit explaining why Richard was arrested. I'm not seeing it. So, key takeaways I'd like you guys to get about reasonable doubt is insufficient evidence that prevents a judge or a jury from convicting a defendant of a crime. If it cannot be proved without a doubt that a defendant in a criminal case is guilty, then that person should not be convicted. And I could tell you, as of today, with them not releasing the probable cause affidavit, they have planted the seed of probable doubt in everybody in the world's mind. Okay? Now we're going to go try to convict this man. Oh, boy. Here's another one. So you want to presume someone innocent until proven guilty. So let me start by giving you this other example. The presumption of innocence is like when you saw me and my client walk in the door today, who here immediately thought, what did that guy do? Then I would compare it to driving down the road, seeing a car pulled over by a police officer, and think, as you're driving past, what did that guy get pulled over for? And show how they're perfect normal reactions, but someone being pulled over is not always criminal, and how dangerous that can be. Presuming someone guilty, well, it may be normal to think that driving in a court of public opinion, that the law requires that a courtroom, you have to have the opposite presumption that my client is innocent unless proven guilty. I hate the word until, since it seems to convey an inevitability. I know, but so again, you have to prove that. You have, and planting the seed, they plant the seed during jury selection. They plant the seed during I would, as a defense attorney, you start planting these seeds in jury selection. You start planting it with your opening statements. You follow up on your closing. I just wanted to bring that up and talk about that a little bit this morning, guys. I know, again, I've been putting out not as many videos of me talking, but it's because, again, people are grasping at straw ends at this point, how I feel. There isn't solid information going around right now. Nothing's solid until the probable cause is going to be released or we have another hearing. Richard is still where he was, still not speaking to anybody and still not talking and not opening his mouth. We'll see what happens and comes of that. I've also brought up to you guys that Richard Allen has been a friend of the Patties for the last 20 years, and that is beyond true. He knows them both very well. They know him very well. Why they're lying and denying that is beyond me. But I just wanted to bring this to you guys live and this morning and talk about probable cause a little bit, reasonable doubt. Again, they need to release that if they want a solid case against this man. Everybody like, subscribe, share. And thanks for the support as always. Coming at you from the TMZ, a true crime, baby. Crime, conspiracies, and coffee. Thanks for tuning in.